Hello and good afternoon, everyone. Thank you for joining us today for our executive briefing, Hospitality Industry Financial Planning for the New Normal. Just a few items before we get started. We have planned a 45-minute discussion with the hopes of answering your questions, so please type them in on the box on your screen. In addition, there is a survey on your screen and we would welcome your feedback. We'd also like to gauge your interest in future discussions. Our goal is to focus future executive briefings to address topics that are important to you, so please provide us with any insight on what specific issues you are currently confronting in this new normal and what issues you would like us to cover in future executive briefings. And with that, I will now turn it over to Dan.
Thank you, Kayla. Good afternoon, everyone. My name is Dan Bachrach. I'm a partner in Foley & Lardner's real estate practice and part of the hospitality and leisure industry team. This afternoon, I'm being joined by three folks esteemed in their areas of practice and advising clients. My first panelist is Rich Bernard, who's a partner in Foley & Lardner's bankruptcy and business reorganizations practice. Also joining us is Chuck Bedsole, who is a senior managing director at Ancura. And finally, Cliff Risman, co-chair of Foley & Lardner's hospitality and leisure industry team and a partner in the real estate practice. Gentlemen, thank you. As we all know, the hospitality industry has been one of the most severely hit industries worldwide. Many forecasters are expecting a sustained period of decline with a subsequent recovery based on a number of factors. We have assembled this panel with intent on providing useful and practical information and guidance for those in the hospitality industry on how to plan for managing cash flow and conserving cash and maintaining liquidity, capital and operational restructuring strategies, understanding and planning for bankruptcy, and payroll and other employment issues. So let's get right at it. My first question is for Cliff. Cliff, in the context of these types of discussions, why are hospitality assets different or more complex than other real estate assets?
Thank you, Dan. In short, the answer is because hospitality assets, specifically hotels, are truly operating businesses, unlike more traditional real estate, whether it be office, retail, warehouse, etc., hotels, restaurants, golf courses, etc., operating businesses with a significant number of employees, all the issues that come along with employees, health and safety issues. They have food and beverage outlets, alcoholic beverage issues. Many times there are franchise arrangements, and so there are franchise issues and the IP issues that go along with those. Although traditional real estate, most often there is some sort of management contract or management arrangement. Management contracts in the hospitality industry are far more complex. Just a couple other points. There's a fair amount of CMBS debt in the hospitality industry, which typically adds another layer of complexity when it comes to the things we'll be discussing today. One other point I want to mention that Rich may talk a little more about later. When we talk about bankruptcy, there are some provisions in the bankruptcy code which enable single asset real estate bankruptcy proceedings to be handled on a more expedited basis. And the view of the courts is, the bankruptcy courts, is that hospitality assets, because they operate other types of businesses, not just collect rent from real estate, food and beverage, etc., are not single asset real estate for purposes of the bankruptcy code. So there's just a lot more complexity than typical real estate.
Yeah, Cliff, as far as the single asset real estate designation goes, many times you don't want that designation. You have to propose a plan on a quick timeline, and these hospitality companies have multiple lines of revenue, which pursuant to which they don't qualify as a single asset real estate case. So that's the short of it. But we could touch on it a little more later.
Great. Chuck, from your perspective, when you have a client come in and they're not coming to you for legal advice, they're coming to you for financial advice, what are the most common concerns that the client sits down with you and raises that first visit or phone call?
Sure. Dan, I believe obviously the first thing is liquidity. When you look across the board and you see just about this isn't about winners and losers like perhaps in the last downturn. This is everybody's basically in the same situation, whether you're a portfolio owner of hotels or an individual hotel owner. So they're worried about, firstly, does it make sense to close my hotel for an interim period of time or to keep it open at a very minimal level? And that's a decision that in some cases, I can give you one example where we have a portfolio of 30 hotels and almost all of them have been closed. And it depends on where you are in the country, geographic region. It depends too on the type of the hotel and where it was before the COVID-19. Some of these were starting to struggle, but for the majority of them, they were in good shape. But those that are kept open, and there's quite a few, obviously, it's really to maintain cash drain. And so a lot of that involves either furloughing or laying off some folks and going down to a very minimal operation, and which means minimal staff. And so even then, how are these owners, whether they have an operator and a brand or whether they're independent, how do they keep the cash flow going? And then one that everybody knows about, obviously, is the PPP program. And, we're into the point now where a lot of that is starting to be funded. And then another area that has been utilized, as the attorneys on the phone know, is accessing the FF&E reserves, which obviously requires some operator brand approvals and lender approvals to do that. But nonetheless, depending upon the hotel and the amount in the reserve, that can get them, the owner, through a certain period of time till we see maybe 3 to 4 to 5 months from now how this is all going to shake out and how quickly we rebound. So that's a couple of the basic comments I would have on that.
Okay, thanks. Rich, similar question for you. Oftentimes, when a client comes visiting to your office or calls you and you start going through the process of heading towards bankruptcy, what are the things that you think they're sitting there thinking to themselves, oh, gee, I wish I had known this 30 days ago, 60 days ago, 90 days ago before I came in, and I would have done something differently? What are those types of things that people need to keep in mind that are windows or opportunities that they need to preserve if they unfortunately have to plan for bankruptcy?
Yeah, Dan, I'm glad you asked. I would say first thing I'm going to tell them is call somebody exactly like Chuck to help them on the business side. But a lot of the issues that come up, particularly with liquidity, where owner or parent company is contemplating inserting new money, maybe in the form of a loan. You may want to rethink that, because no good deed goes unpunished. If you eventually do file bankruptcy in 30, 60, 90 days, a lot of times that money in is going to be considered a contribution of capital. Whereas if you kept that powder dry for the bankruptcy, you could use it there are certain requirements in getting out of bankruptcy, and if you want to retain ownership coming out, there's a new value requirement. So if you can keep that powder dry and use it in the bankruptcy, you can get a lot more out of it. Other issues that come up for me are questions about D&O exposure, zone of insolvency questions, And when we get into that, if you're a director and officer and you owe fiduciary duties, you owe them to the company, regardless of the zone of insolvency. And Delaware has really clarified that up over the past few years. There's different considerations when you're in a zone of insolvency, and certain stakeholders may raise an importance in your considerations, but you just need to keep informed of your options, hire professionals, rely on professionals within the areas of their expertise, and that can be a minimal issue. The other thing too is it's important pre-bankruptcy. Make sure you're current on your responsible person taxes. These are like withholding taxes. Even now under COVID, there's a big question going on where you have money, you're trying to conserve liquidity, you do have a bit of a deferment available from the government on payment of these taxes. But if you don't pay them and then go into bankruptcy, is there going to be an issue where the government, the IRS, is going to start looking at certain directors, certain officers under their personal liability? But most important, heading into a bankruptcy is develop your end game, put sticks in the stand. Those sticks may be moved, but those are your end goals. And you may have two lines. You may be pursuing a sale and a restructuring exit, and also make sure you have the liquidity to get there. So you have to make sure you're arranged for your debtor in possession financing in the bankruptcy, and what your game plan is to get out of bankruptcy. And then finally, there's a couple more things, but just to keep it short, if there are material leases or contracts, you need to get into bankruptcy before those are terminated. That is critical. I mean, especially with hotels and real estate here, restaurants and the like. If you're in a situation where your potential, significant contract or lease is going to be terminated, you need to be in bankruptcy before the termination goes effective. You can breathe life back into that contract or lease in the bankruptcy if it's not terminated, but in most cases where it is terminated, you're out of luck. And then I'd say finally, be careful on your intercompany and insider transactions. I mean, you want to establish arm's length dealings with these companies. It creates a lot of issues for creditor committees to start digging into this. Dividends and transfers to insiders. So if you're privately held and you're pulling money out of the company within a year of a bankruptcy, it's potentially could be clawed back into the estate. And if creditors are getting whacked in the bankruptcy, there's a good chance that's going to be pursued.
Great, thanks. So Chuck, we hear, liquidity. So what are thoughts? You mentioned PPP, you mentioned using the hotel reserves, which would require the hotel manager and or the brand's consent to do. But what other tricks or thoughts do you have on preserving liquidity, cash flow, and conserving cash?
Well, I think one thing I didn't mention is, and this is what we've seen firsthand, is the first round of forbearance on 90 days has kind of taken place in the books or about to be closed, and now we're seeing a lot of our clients going back for an additional 90 days, and the verdict's out as to how all of that will be accepted by their lenders the second time around. So I think that's really a key strategy, and I don't think, obviously while everybody's trying to see how this is going to play out, it's not a dishonorable ask. It's, I think, a legitimate ask, and from what I'm hearing, a lot of the banks are begrudgingly going along with it. So I would say that, and I would say secondly, just like in the days of the last financial crisis, you know, some of the first calls I got, believe it or not, were folks that had some rescue capital out there, and they're not widely advertised, and it might be tantamount to doing a deal with the devil. But there are some funds out there, you know, with certain targets and certain types of conditions, and you know, perhaps some of them are even vulture capital types that really want to get a hold of the asset. But there's a market out there that's looking to invest in some deals that maybe if the sponsor doesn't have what it's needed to take it forward and the asset's worth it, they're willing to invest. So that's what comes to mind off the top of my head.
Oh, Chuck, I was going to add to that. You're absolutely right. I mean, I noted that I heard that there's a bunch of big firms, big PE firms out there that are doing capital raises for new special situation funds, like Angelo Gordon, over $2 billion, Blackstone $7 billion, Carlyle $3.5 billion. I mean, they're big players out there raising capital right now to swoop in and, you know, pick up on these opportunities.
Well, the practical reality is, though, and this is Cliff, the practical reality is that funds of those magnitude need to invest in large companies, large tranches of money, portfolios, operating platforms for the one-off hotel owner or the owner of 5 or 6 hotels. That's not realistically where they can access capital, because it's just not enough to move the needle for any of those large opportunity and PE funds that you're talking about.
Yeah, well, there's smaller ones too. Cerberus at $750 million, Grey Wolf at $400 million. So I mean, what I'm getting at is there's a lot of PE funds that are raising capital, and they're looking for situations, investment opportunities here. But yeah, as Chuck said, you may be doing a deal with the devil. In my experience, if you're dealing with your lender and you can be as transparent as possible, hiring a financial advisor like Chuck that they respect and knows will give them the true scoop of what's going on and what on the ground, and what the opportunities are, and you know, can develop a strategy to get back to whatever the new normal is. And I think we'll get into that a little bit. You know, that goes a long way to getting additional money out of your current lenders, and keep the lights on and maintenance on your properties and be able to reopen when you can reopen.
So moving in a different direction, Rich, when a company declares bankruptcy, what do they accomplish through that bankruptcy, and what happens to all the contracts that are out there? I'm going to ask Cliff a similar question about management contracts and other hotel-specific contracts, but if you could discuss generally, what does a company get through bankruptcy when they come out, and what happens to all those contracts that they have for weather linens?
Yeah, immediately when you go into bankruptcy, you get the benefit of an automatic stay. That prevents your creditors and your counterparties from taking action against the debtor or the debtor's asset. And so that gives you that breathing spell. If you've done what we talked about before in developing your exit strategy, you have an idea where you're going to go to, and you've put in place the capital in order to get there. Through a bankruptcy, you really, you could perform a capital or operational restructuring, and that would be through a Chapter 11 plan. You can accomplish a sale, mergers and acquisitions, and you can do that either through motion practice, through the Section 363 of the Bankruptcy Code allows for not ordinary course sale of assets, and it is an asset sale, but you can sell the whole business under this with minimal, if any, successor liability issues. And then finally, you can also liquidate in a Chapter 11. And you're liquidating under your watch rather than a trustee's watch. So those are the main things that you can get out of a bankruptcy. I mean, most of the time you want to stay away from that single asset real estate case because the expedited time frame in which you have to propose a plan and get out of bankruptcy. With respect to executory contracts and unexpired leases, so long as they haven't terminated, you have the ability to assume them or reject them, or assume and assign them to a buyer or a successor. And the assumption requires you to show that you can perform under the contract going forward. You're also going to have to cure any defaults or damages that exist under the contract upon assumption. Rejection, it allows you to terminate the contract. So this goes potentially to that operational restructuring, where you're looking at your footprint and you're determining based on your four corners analysis, hey, we need to drop locations here, in these 3 places or 10 places or whatever. You have an ability to do that. With leases, when you reject them, the pre-petition damages are limited to at most 3 years of rent. And then with assumption and assignment, even if there's, in most cases, anti-assignment provisions in the agreement, which requires the counterparty consent, in most cases, the bankruptcy code allows you to override that as long as the assignee can show that it has the ability to perform in the future under that agreement. And so there are exceptions to that, and we'll get into that a little bit. It touches upon intellectual property, which comes up in your licensing.
Great, thank you. Cliff, I'd like you to help us with a little bit about the specific, hotel-specific type of documents, the management contract, the franchise agreement, and license agreements.
Sure. To follow up on where Rich was going, they're treated differently than leases. They're absent when you get to the end of the bankruptcy where there's an accept or reject concept for these contracts. They're not accepted or rejected or assigned in the initial periods of a bankruptcy proceeding. They remain in effect, obviously, during the proceeding, although the debtor has to perform. The automatic stay that goes in place prevents the counterparty, the management company, or the franchisor from taking unilateral legal action normally without the filing in and consent from the bankruptcy judge. A couple of very specific things to keep in mind. What the lawyers call ipso facto clauses, the provision in many contracts, management agreements, franchise agreements, that say the filing of a bankruptcy constitutes a default by the party that filed. Those provisions are unenforceable in bankruptcy. I mean, they're in agreements in the unlikely event that for some unique reason someone was able to convince a bankruptcy judge to enforce them, but they are generally speaking unenforceable. The one other thing I want to mention, because it really relates to the financial situation, the analysis of, do you want to keep your management company? Would you like to get out of that management agreement if you're an owner? Do you want to keep your franchise in place? Would you like to get out of that franchise agreement, change flags if you're an owner? Can be significantly impacted by key money, because there are many hospitality assets where either a manager or brand, or in some cases they're one and the same, have put money into the asset, normally by way of key money, and that key money has to be repaid in the event those contracts are terminated. Obviously, I'm overly simplifying this. At least the unamortized portion of the key money becomes due and payable, and that takes a contingent liability and turns it into a current liability in the event those contracts are terminated. And so that analysis has to be part of the decision about, do you leave a counterparty to a contract in place or not? I mean, those would be the big issues.
Yeah, and on the bankruptcy side, the licenses and the franchise agreements, there are different rights associated around that, and you're going to have to talk to your advisors on the best approach here. I mean, intellectual property that's exclusive versus non-exclusive are treated differently in a bankruptcy, and so you're going to want to look and talk to your advisors regarding those issues, and how a bankruptcy would impact those types of agreements too.
Thank you. So what about all of the licenses that you get, not the intellectual property licenses, but operating permit type of licenses? Cliff and Rich, any thoughts on those?
I mean, Rich, go ahead. I generally speaking, I don't believe they're affected as long as the currently due payments are made during the pendency of the bankruptcy.
Yeah, that's true. I mean, the issues come up with the assumption and assignment of licenses, more so than what's going on in the bankruptcy. However, I've been involved in a hotel and in the branding of a hotel that went into bankruptcy. This is years ago, but some of you may remember Howard Johnson. Howard Johnson was able to terminate the branding, the franchise for this particular hotel, and we kind of, in order to get out, we had to cut a deal with another name. But that said, if you're operating under a franchise, there are certain rights that the franchisor has to maintaining the brand, and so it's an issue which you can negotiate around, but again, you're going to have to, you're not going to want to surprise your franchisor with your bankruptcy. You want to give them some visibility, some preparation for this. Hopefully you have a good relationship, a strong relationship with them, and they're going to be supportive to get you through the process, so you can recapitalize or, effectuate the changes in your capital structure or whatever you're trying to accomplish through the bankruptcy.
So Rich, Cliff hinted at this issue as a potential driver of behavior was the key money, but lots of times the key money is subject to a personal guarantee by one of the individuals or entities up the chain. What happens to personal guarantees? I know that there's a dichotomy, if you will, between the entity declaring bankruptcy and the individual or other entity that gave the guarantee, and sometimes there's, it may be all driven by the same director sitting at the table wearing multiple hats. And so how do you advise folks about what's going to happen with the guarantee, what's going to happen to how they need to behave with that guarantee hanging over their head and that sort of?
Yeah, and I know this is one of the questions we received from an attendee. Yeah, personal guarantees are tricky. Most of the time, the banks take the personal guarantees to make sure that the key person at the debtor does what they want them to do. Not, in most instances, I don't really think banks expect to recover on personal guarantees. It's a pressure point. However, the company goes into bankruptcy, the personal guarantor is usually not a debtor. And so there is a friction here because the automatic stay applies to the company and the company's assets. the bank technically can pursue the personal guarantee. Now, in doing so New York is a little different, and most loans, apply New York law, but you have choice of remedy provisions in New York, which is good for the personal guarantor in this situation, where if they choose to go after the guarantee, it's a choice of remedies, and so it gives you a little bit of protection. A lot of the loans, though, sort of waive those provisions in New York law. What it comes down to, if you have a very contested situation and you need this key person to participate, both with their time and with their money in the bankruptcy case. So your plan is a new value plan. They're coming up with new money to recapitalize the debtor. You can ask the bankruptcy court to extend the automatic stay. In large cases, it's done very regularly. I just saw it done in Boy Scouts of America about 2 weeks ago to protect all of the local councils from any litigation. And they're not debtors in the bankruptcy. In the smaller cases, it's tougher, but it's needed even more. I mean, the factors that are cited to support extending the automatic stay to a non-debtor, those factors, in my experience, exist in spades in the smaller cases, and protecting that personal guarantor from litigation and so on, so you can actually run a bankruptcy case effectively and get in and get out. So that said, you could potentially extend that automatic stay, not permanently, for a period of time, so that you can get a plan on file, and depending what that plan says and does, you may be able to, affect that personal guarantee. But at least, the guarantor in that situation, if you're coming out because you put some new money in to recapitalize the debtor, you're coming out with an asset, versus if everything goes down, you're stuck potentially in lawsuits on the personal guarantee, and there's no and you don't own the asset.
Dan, one other thing I would mention, because it's related to the guarantee issue, are letters of credit, because many obligations of hotel owners are secured by letters of credit, and the ability of the beneficiary of a letter of credit to present that letter of credit and receive payment is not stayed by the bankruptcy filing, and that letter of credit is viewed by the courts as a separate independent obligation. So if someone's considering filing bankruptcy, one thing it would not do would be prevent the holder of a letter of credit that they issued or had issued to secure an obligation from presenting and collecting on that letter of credit.
That's a good point. Thank you. So, Cliff, go ahead.
Yeah. So yeah, Cliff's right. A lot of those letters of credit are well, depending on who the debtor or who the party is, may be backed by cash. And although the bank that issued the letter of credit has to pay on its letter of credit, it may not be able to grab the cash without authority from the bankruptcy court, specifically to get stay relief in order to glom onto that.
That goes on the list of things you need to know when you're headed in down the spiral. So one thing that we see often in hotel and now in many urban timeshare resorts are collective bargaining and union agreements, and how do they play into the staffing and benefit decisions and the planning for liquidity that we've been looking at? Because I know that they provide limits on flexibility, but Cliff, could you discuss a little bit about that, please?
Yeah, the short answer is that you have the union shop or you have a collective bargaining agreement in place with respect to your employees, as a technical matter, your ability to make some of the decisions that owners have been faced with and that Chuck alluded to before, you get hamstrung a little bit, because in theory, the ability to do workforce reductions, salary reductions, changes in benefits, changes in work rules requires discussion, negotiation, consent from the union. Now, the reality is, from the discussions I've had on this point, everybody is very cognizant of what's going on, and unions have generally been cooperative as to short-term changes. But as a technical matter, when you don't have a union shop, particularly in an at-will employment at will state, if you decide you're going to close and lay off or furlough all of your employees other than a couple of security guards or engineering people to keep your facility operating, you have the unilateral ability to wake up one morning and do that. And when there's a collective bargaining agreement in place, technically you have to do it through the union. The one other thing I'd add, because there are situations where the hotel owner is a party to the collective bargaining agreement, and there are other situations where a large management or a branded management company might be the party to the collective bargaining agreement through a master collective bargaining agreement that affects multiple assets, and that then adds yet another layer of complexity in dealing and getting consents and accommodations from the union.
Yeah, Cliff, it doesn't change a whole lot immediately in bankruptcy. So you go into bankruptcy with your CBA in place, and it is an executory contract, but it's one that you cannot just unilaterally terminate. The bankruptcy code, the union is a powerful lobby. There's laws on the books. You have to do a good faith dance with the union to renegotiate the CBA, and until and unless you hit an impasse on that good faith dance, you're not allowed to just to reject that CBA.
Really quickly before the next question, we're headed into the last 5 or so questions. We're 38 or so minutes into our presentation. So we do want to leave time for questions. We have a few more pending, but if you all have any questions, please feel free to submit them so that I can have them asked and answered of the panel. Chuck, let's change this turn into a new direction and discuss our friends, the lenders. And what do you think, and how do you think lenders are going to deal with their borrowers, and what's their analysis and approach going to be? Do you see this headed to a slew of foreclosures and note sales? Or any sense of what you're hearing and seeing out there? I know it's really early in that process, but want to get your sense of what people might expect in the next 90 days.
Yeah, I think underlying the comment early in the process, I think thus far, unless and by the way, there were some deals, both portfolio and individual assets, that were in trouble for one reason or the other before the COVID pandemic hit. And I think that's kind of a different set of circumstances than just the rest of the industry. But, I think that I've seen a couple of situations that seemed almost too friendly to me, where there's been some deed in lieu of foreclosures, which kind of surprising. But again, that may have been something that was in the works beforehand. And these are on big assets. And so, I think that I think they're making two sets of plans. Each of the big lenders have parallel plans, which says one plan is if this gets to the point to where, that doesn't look like it can be restructured, then we'll foreclose and deal with it. And then I think the rest of them, and it depends too on the lender and what their portfolio is and how much how much hospitality and leisure product they have in it. But I don't think it's going to be just, just a rush to the land office window. I think it's going to play out a lot slower. And that's just my humble take on it. And I'll tell you the other thing that we didn't touch on, but a lot of these folks, now that we've kind of worked our way into the close down, I'm seeing a lot of situations where everybody's planning on reopening these assets, and that may influence, what happens with the lenders and obviously the assets themselves. And I know a lot of these companies that we've been talking to are, the first thing they're doing is scrambling, trying to find their employees after they've been off for 5 or 6, 7 weeks, however long. And then in addition to retrofitting their properties, and I think a lot of them are basically, and I know the brands haven't been 100% quiet, but I know what they're doing, and among other things, is they're figuring out, okay, in this new environment going forward, we're going to have to totally rewrite a lot of our brand standards around sanitation and cleanliness and everything else. Not that they weren't fine to begin with, but we're in a new reality. So that's a long answer to a fairly short question, but that's my 2 cents.
And Chuck, it's Cliff. Let me ask kind of comment/question for you to elaborate. Is it your sense that with lessons learned from 9/11 and from 08, 09 and other prior events, that lenders will be more likely to unload the paper at a discount than they will be to have any interest in foreclosing and taking assets back?
Yeah, I think you're going to see that. I think somebody alluded to that earlier in the call, that a lot of that's kind of going on behind the scenes. And, it just depends upon is there a market, which we probably think there is, how big is it? And, how are these notes going to trade? I think that's probably, you're going to see some of that for sure, Cliff.
Yeah, Cliff, this is Rich. I honestly, the banks, so when the banks hit underperforming and non-performing loans, they have to report that and they have to take reserves against it, which gives them a double whammy. Not only are these loans not performing or underperforming, but they gotta keep more capital in the bank than they otherwise would have to. And so, there is incentive to move the paper.
Any other thoughts on, without beating this to death, Cliff, you will have any other follow-up thoughts on where we're headed to in terms of the transaction world? You and I have seen several transactions. Most of them have kept on going that you and I are working on, but there are a couple that are sitting still, and I think most of it has been because of other issues, not necessarily because of the current situation.
Yeah. Look, if I had $1 for every time I told somebody recently, if I knew the answer to that question, I wouldn't have to work anymore. Nobody knows. My sense from talking to people, our clients, both on the ownership side, the management side, the lending side, is that when the health issues subside, hopefully sooner rather than later, the financial ramifications of what has transpired will take the rest of this year, who knows, all of next year, to work their way through the system. And the next couple of years, it's kind of a crapshoot. There was somebody alluded earlier to all the capital being amassed on top of the dry powder that already existed. In a lot of hedge funds, PE shops. And if you think back, a lot of those household names that were mentioned earlier that everybody knows who they are, those folks either were created during a financial crisis or made significant amounts of money during prior financial crises when assets changed hands and the smart folks on Wall Street figured out what to buy and what portfolios to buy and which companies to invest in and which notes to buy. And every time there's a significant distress situation like this, there are winners and losers. And I think the same thing will play out over the next several years with a significant transfer of assets and significant opportunity for those players who have dry powder to make a lot of money.
So, Chuck, I mean, certainly there's going to be nothing in particular have we seen like this before in this area. So we have folks always, when you have a opportunity that will say that attempt to get the asset on the cheap, and the owner will have a higher valuation, given that this is a truly exogenous factor that has caused this situation and a unique solution to the problem. How would you advise folks on purchase and sales discussions on both, either for the opportunist or the asset holder? What advice do you give in achieving their goals?
Yeah, I would say keep your eye on one thing that often kind of gets overlooked, and you can look at the financial fundamentals of an offer of a sale. You can look at can you reject this contract or do that, or do you have the right brand? What I would, and I don't have the answer, but what I would really that's really made an impression upon me is how long and how deep are some of the fundamental changes for the business traveler and the leisure traveler, and their preferences and their psychologies are going to impact the comeback of hotel performance. And the airline's part of that value chain, and I don't know. I think you got to underwrite it really considering several cases, and how fast are people want to come back to meetings? When are they going to want to jump on a plane to go to Cancun or wherever? I think you got to really understand that traveler mentality and the impact of all of this, because no matter what you pay for it, or what you sell it for, it may be too much. You may pay too much, or it's really, that's, to me, that's the biggest wild card. The underlying financial fundamentals can be dealt with.
Right. I agree with that exactly. I had a note here on the new normal, and the new normal is, what are the customer preferences going to be in the short, intermediate, long term? They may get back to where they are now, but how long a wait before that happens? And 9/11, there was some impact. I mean, I think it's going to go deeper than 9/11, and God forbid if there's a second spike somewhere, or especially in a heavily traveled area, that's going to have an impact. So the forecasting new customer preferences is going to be very important in trying to figure out underlying value here.
Yeah, I mean, certainly on any given day, this could disappear or continue. The thing with 9/11 was we didn't know how long the change and the fear was going to last, or what the next event would bring. So uncertainty is never the friend of folks who are trying to plan and value.
Dan, this Cliff, may I interrupt and mention one thing?
Sure.
I actually got an email a little while ago that I tried to read quickly while we were doing this presentation. We haven't really talked about PPP loans, but I just saw something that really does relate to this conversation that perhaps some others have seen, but I was not aware of. And that is that although it was not provided specifically in the CARES Act, the SBA had been taking the position that debtors in bankruptcy were not permitted to apply for the PPP loans. And apparently, I just learned that in a case in the Southern District of Texas, a federal judge has enjoined the SBA from taking that position on the grounds that they couldn't preempt the bankruptcy code by some sort of SBA rulemaking. And I don't know where that goes, but it's very interesting in light of whether bankruptcy would or would not affect someone's ability, assuming there's more money left in the system to obtain a PPP loan.
That's
Yes.
the key.
Cliff, this is Rich. There are two other courts that have also ruled likewise. And what it comes down to, there's a provision in the bankruptcy code at section 525 that says the government cannot discriminate against a person because they are in bankruptcy. And that's the key there. So the government can't deny your application because you're in bankruptcy.
Interesting.
They can deny it for other reasons, but not because you're in bankruptcy.
Yep.
So, Chuck, Cliff, Rich started talking about his visions of the new normal. Anything else that you'd like to add of what predictions or thoughts on what the new normal will hold?
I think it's just going to be rapidly changing. I mean, what's kind of envisioned today is going to evolve, and is there a rebound? And I don't know, but it's not going to be a V-shaped rebound like some of us heard was going to happen.
Yeah,
there's
and
going to be a lot of
Chuck,
effort in forecasting.
Chuck's bailiwick, but I think it's going to take a long time. Chuck mentioned this for there to be a meeting of the minds between buyers and sellers, valuations, where cap rates are going to wind up as a result of what's transpired. It's going to be a process, and that's on the on the macro end. And on the micro end, I can only tell you we've started to open up here in Dallas. And the other night, I walked into a Mexican food restaurant for the first time I've been out to eat, obviously, in months. And, sitting at every fourth table and being served by someone with a mask on and gloves, it's just an example. Nobody knows how long it's going to last or what's going to come next.
Cliff, I thought you get used to sitting at those types of restaurants that they serve you with masks.
So I want to turn to some of the questions that we've received from the attendees, and some of them we've answered in part, but I'm going to read them just the same to see if anyone has any additional insight. First question, I'll read it directly, is with respect to the broad-based conversations you're having with your respective clients, with the recognition that each situation is different, what are you seeing from the market participants in terms of tenor of those that may be considering bankruptcy, defaulting on franchise obligations, rescue capital, etc.? Provided the broad-based industry dynamics and bleak forecast for the industry, what are some of the more subjective observations you anticipate?
Let me take first stab at this. I mean, we're advising some restaurant chains right now, and the banks on those chains are not pressing us. I mean, we're not servicing the mortgage. We're not paying rent, so the landlords aren't pressing us. There's no need to file a bankruptcy now. The clients are getting access to PPP loans, and so they're waiting for a chance to reopen. And these chains are really not profitable at 25% capacity. They're probably going to have to wait a little longer until we're further down the road on reopening. But there's going to be a bill that comes due. I mean, but right now, while they're conserving cash, they're looking at their four corners analysis. They're determining their footprint, and in most cases, shrinking that or planning to shrink that footprint. So, and in doing so, there's a lot of leases that we're going to shed, and that's probably going to be done through a bankruptcy at some point. On the hotel side, I'm not currently advising any hotels. I have in the past, but the reports I'm seeing, good, I guess the good case is, revenues are down 20-30%, but that is significant enough to impact hotel ability to service, to make debt service. And so, there's going to be issues there. Again, I don't think the lenders are going to press right now or in the near future, but eventually there's, the bill's going to have to get paid, and how is that going to happen? And I think, talking with some industry professional experts in the industry and in bankruptcy can help you plan for what the next step's going to be.
Dan, the one thing I would say in answer to that question, in talking to clients daily about a myriad of issues related to this, and maybe it's a very good comment about people in the world we live in, but I have been very, very surprised at the spirit of cooperation and working together between owners, managers, brands, lenders, equity partners, the people that I have seen taking advantage of this situation and perhaps trying to come out on top have been far and few between. It really has appeared, at least in the situations I've been working on, the clients I've been talking to, that everybody views it as, this happened to us, it's no one's fault, and we're all in the boat trying to bail the water out and keep it from sinking, and we're in this together.
Good point. So one more question for the group. The cause of the massive loss of equity in the crisis is medically caused, unlike earlier similar situations. The cause is not related to poor management practices, meaning to me that a lender is not likely to hire a management company that can improve operating performance. Wouldn't lenders be less likely to take property back and more willing to work something out on loans where that is possible? I think we've mostly answered that, but if somebody wants to add to that, I think, Cliff, basically, you would agree that, and so Chuck, would you, that, absent some historical problems that we're seeing going into this crisis, that the banks are going to sit this one on the sidelines for a little bit and see where things go. Thoughts?
Yeah, this is Chuck. Look, a lot of these banks were there when obviously when the lender was part of the discussion and came into the operator and the brand. I mean, there may be a couple of cases or a handful of cases where, as a result of this, an opco or a brand gets changed for one reason or the other. Maybe this is, maybe a convenient time to do it. But generally speaking, I think you're right. I mean, things were going along pretty well, sailing along pretty well before, 6-7 weeks ago.
Yeah, absent malfeasance, I think that's dead on. There'll be the isolated situation where people have behaved badly and their lenders will act differently. But because of the reason this has happened, absent malfeasance, I think Chuck's dead on.
So before we say goodbye, a couple of things I'd first like to thank each one of you for joining us today. I'd like to thank Chuck, Rich, and Cliff for their insights. This session was recorded, so if you enjoyed the content, you'll receive a link later after this session, and you can forward that link to others that you believe will, in your organization or your other colleagues that you may know in the industry that may benefit from this. We would like to plan on holding more of these sessions in the coming weeks. If you have specific topics or questions you'd like to have the panel address, please include in the survey or provide to us in the form of a question now. As a reminder, we would appreciate it if you could fill out the short survey on your screen and invite you to sign up for future briefings. Finally, in order to fit the content that we've gone through into literally 1 hour that we just are hitting right now, you can imagine we've stayed at the 30,000 foot level. If you have any questions that you would like to explore further, you'll feel free to contact or reach out to me or any of the speakers. You'll get our bios as part of the follow-up from this webinar, but we hope to be in touch with you for future webinars. Thank you, stay safe, and goodbye.